Good morning, this is the Kelso Report for Wednesday, September 26th, and I'm your host, Clark Kelso. Our cases today involve the proper interpretation of the National Childhood Vaccine Injury Act, the question of whether successive acts of vandalism may be aggregated for charging purposes, and whether drunk driving is an offense that disqualifies a defendant for diversion to a drug treatment program. We begin with the Ninth Circuit and vaccines. One of the known problems with vaccines is, of course, that a certain number of persons who receive a vaccine will actually develop the illness the vaccine is designed to protect against, or will develop some other harmful side effects. For manufacturers of vaccines, this presents a serious business challenge in the context of America's tort system, where, absent some type of legal protection, manufacturers could anticipate having to pay large damage judgments every year to a small handful of seriously injured persons, even though the overall benefits to society justify widespread use of the vaccine. Congress first recognized the problem back in the 1970s after a series of cases involving the swine flu vaccine, and ultimately in 1986 enacted the National Childhood Vaccine Injury Act. The act, which broadly deals with vaccines, established an administrative compensation mechanism and, through a series of preemption clauses, prohibits states from regulating large aspects of tort suits against vaccine manufacturers. The precise issue before the Ninth Circuit in Holmes v. Merck was whether the act preempted a tort claim filed by the parents of an infant who suffered a serious reaction to the standard measles, mumps, and rubella vaccine and ultimately died from complications. Now, on behalf of the infant's estate, the parents had recovered $250,000 from the government's fund that's established by the Vaccine Act. The parents then sought further damages for themselves from the drug manufacturer based on claims of wrongful death, negligence, strict product liability, negligent design, failure to warn, misrepresentation, express warranty, implied warranty of merchantability, implied warranty of fitness for particular purposes, and punitive damages. They threw in the whole kitchen sink. Well, the district court ultimately granted summary judgment to the drug manufacturer on all claims, and the Ninth Circuit affirmed. The evidence submitted by the drug manufacturer established that it had complied with all regulatory requirements, and plaintiffs failed to submit evidence to show the vaccine had not been properly prepared or that it had not been accompanied by proper directions and warnings. And in these circumstances, according to the Ninth Circuit, the Vaccine Act protects the manufacturer from tort liability pursuant to state law causes of action, even ones brought by the parents who otherwise were not entitled to recover any compensation under the Act. Broad protection for the manufacturers. Next, we turn to state criminal law and the doctrine of aggregation. In the criminal law context, we have a number of property crime statutes that have dollar amount triggers. For these statutes, how you calculate the value of the property involved can make the difference between a misdemeanor and a felony, and between a short sentence and a longer sentence. In People v. Carrasco, the 2nd District held, in a case of first impression, that where a defendant commits multiple acts of vandalism pursuant to a single general impulse, intention, or plan, the fact that the damage is to property owned by more than one victim does not preclude aggregation, resulting in an offense of felony vandalism. Factually in the case, after an argument, the defendant threw a statue through the front window of the house where his mother was residing, and then broke the windows of her car that was parked on the street. He argued that because his father was the sole owner of the house, and the damage to the house and car individually did not total $400 or more, he can be convicted only of 2 counts of misdemeanor vandalism. But the 2nd District rejected this argument and held that where a defendant engages in vandalism that causes damage to the property of more than one victim, aggregation of the damage amount is appropriate when the damage did not result from separate and distinct criminal acts and was inflicted pursuant to a single general impulse, intention, or plan. On the facts of the case, the successive acts of vandalism were pursuant to a single angry impulse, so the aggregation of the damage amounts was appropriate, and his conviction for felony vandalism was affirmed. Next, we talk about deferred entry of judgments in a drug context. In California, we have established drug diversion programs so that many people charged with possession of drugs are diverted into treatment programs instead of sent to jail or prison. In People v. Orozco, the plaintiff pleaded guilty to possessing cocaine and driving under the influence of alcohol. The Superior Court sentenced him to 60 days in jail and 3 years of probation for driving under the influence of alcohol, but granted him deferred entry of judgment under Penal Code Section 1000 for possessing cocaine. To satisfy the deferred entry of judgment requirements, defendant enrolled in, but was eventually terminated from, a Section 1000 drug treatment program. He moved for reinstatement in the program. The Superior Court then denied the defendant's motion on 2 alternative grounds. First, the Superior Court, a different Superior Court judge this time, held that the defendant's drunk driving violation rendered him ineligible under Section 1000, Subdivision A3, for deferred entry of judgment on the cocaine possession charge. And second, defendant had performed unsatisfactorily in the drug treatment program by failing too long to enroll and participate in a timely way. Well, the 1st District held, on the first reason given by the Superior Court judge, that the Superior Court had misinterpreted Section 1000A3. As the Court explained, that subdivision disqualifies a defendant for deferred entry of judgment if he or she has violated an ineligible offense related to, quote, narcotics or restricted dangerous drugs, close quote. Well, as used in Section 1000A3, alcohol is neither a narcotic nor a restricted dangerous drug, and it was therefore improper to deny the defendant re-entry because of drunk driving violation. Notwithstanding this error, the 4th District affirmed the judgment because it agreed that the defendant had not satisfactorily performed in the drug treatment program. But the Court's holding, 4th District's holding, clarifies that drunk driving does not keep you from being referred to a drug treatment program under Section 1000 of the Penal Code. And that's it for today's Kelso Report. Have a great day in the law.